Thanks, the gentleman, and now recognize the gentleman from Wisconsin, Mr. Sensenbrenner.
Well, Mr. Chairman, at the risk of having the flag thrown at me for piling on, I want to get at the whole business of who decides what's relevant. Both the chairman and the ranking member have said that the Patriot Act was amended in 2006 to include a relevance standard. Yesterday, I got a letter from the Justice Department, which was at great length explaining this, and I'd ask unanimous consent that this letter be placed in the record at this time.
Without objection, it will be made a part of the record.
Part of that letter said that, in effect, that all of the phone calls, meaning the telephony metadata, had to be collected pursuant to the court order, and then it would be up to the security apparatus to make a determination of which needles in that large haystack were relevant to a foreign terrorist investigation. Now, doesn't that mean that instead of the court making a determination of relevance, it's the security apparatus that makes a determination of what's relevant and which of the less than 300 series of phone calls get picked out according to your testimony? Mr. Cole, would you like to answer that?
Yeah, Mr. Sensenbrenner, I'm happy to address that. What the court does is it sets out a framework and a set of rules that we must follow to implement its orders.
But they don't determine which specific phone calls are relevant pursuant to the statute. You do that.
Well, we report to the court periodically on the implementation of this. We get it re-upped every 90 days when there are...
But you do that. The court does not.
The court does not.
Now, if there was a criminal trial involved, it would be the court that would be determining a relevance standard pursuant to subpoena or for proffered evidence, wouldn't it?
Not necessarily, Mr. Sensenbrenner.
Okay, well then let me continue on this. You know, I've been the author of the Patriot Act and the Patriot Act reauthorization of 2006. Mr. Conyers was correct in saying why the relevance standard was put in, and that was an attempt to limit what the intelligence community could be able to get pursuant to Section 215. It appears to me that according to this letter and according to the testimony of FBI Director Mueller, that relevant was an expansion of what could happen rather than a limitation when the law was amended when relevant was not included in that statute. And doesn't that make a mockery of the legal standard because you're trying to have it both ways?
I don't think we're trying to have it both ways.
Well, you sure are, because you're saying, you know, authorize, have the court authorized to get us the records of all the phone calls that are made to and from phones in the United States, including people who have nothing to do with any type of a terrorist investigation. And then what you're saying is that we'll decide what to pick out of that mass of maybe 1 billion phone calls a day on what we're looking at, rather than saying this person is a target. Why don't you get an authorization only for that person's telephone records?
Again, going to the analogy of the criminal context, we would never, in a grand jury situation or in an investigation that's a traditional criminal investigation, even go to a court for the framework or the setting of rules, or have sunsetting every 90 days of the authority, or having compliance procedures.
But Mr. Cole, with all due respect, the letter that I got from the department that you're the number 2 person in says that you get the FISA court order because they're, quote, reasonable grounds to believe that the data is relevant to an authorized investigation to protect against international terrorism, as Section 215 requires, even though most of the records in the data set are not associated with terrorist activity. So you gobble up all of those records, and then you turn around and say, well, we'll pick up, you know, maybe 300 phone numbers out of the billions of records that you have every day and you store for 5 years there, and all the rest of this stuff is you know, sitting in a warehouse, and we found out from the IRS, who knows who wants to have any kind of legal or illegal access to it. You know, you are having it both ways. And, you know, let me tell you, as one who has fought Patriot Act fights, usually against the people over on the other side of the aisle, Section 215 expires at the end of 2015. And unless you realize you got a problem, that is not going to be renewed. There are not the votes in the House of Representatives to renew Section 215, and then you're going to lose the business record access provision of the Patriot Act entirely. It's got to be changed, and you have to change how you operate Section 215. Otherwise, in a year and a half or 2.5 years, you're not going to have it anymore. Now I yield back.
Chair, thanks, gentlemen. Recognize